News, fresh perspectives from all over the continent and beyond. And now here's a story that we've been tracking. Two Ghanaian nationals filed a petition recently with the International Criminal Court asking for a preliminary probe into anti-immigrant violence in South Africa, claiming the attacks amount to crimes against humanity and accusing the South African government of failing to stop the abuse. South Africa has rejected the petition, maintaining that it has robust constitutional and legal mechanisms to address xenophobia and violent crime. To look at this further, we're joined now on the line by Professor Angelo Dube, who is an expert in international law and human rights. Professor Dube, thank you so much for speaking to us. So let's just start off by looking and understanding this case in terms of what constitutes a crime against humanity under international law. And I also want to understand the bar that has been set by the ICC if one were to bring a case like this before them.
Thank you so much for having me. The Rome Statute is clear that for any crime to constitute a crime against humanity, there must be a series of crimes, one of a number of listed crimes which must be committed, and they must be committed in a particular way. These crimes include your murder, it includes your displacement or forced removals of a certain people or group of people. But it's not just any forced removal or any murder or attack of that nature that constitute crimes against humanity. The crime or the manner in which this is done must meet a particular threshold. The threshold has two elements. The first element is that it must be widespread. In other words, it mustn't just be random acts that occur on a daily basis. To have random acts happening in our society on any given day. It mustn't be sporadic incidents, but must occur in various spaces in a manner that shows a pattern of widespreadness. The second element is that it must also be systematic. So it's not just people waking up today doing one thing and then next week doing a similar thing, and then we call that crimes against humanity. There must be a systematic way of doing this or committing this particular crime. In other words, there must be some policy, either of the state that is being accused of sponsoring this or of the organization that is being accused of sponsoring those crimes against humanity. So in short, that's what crimes against humanity look like.
And I also want to your point, understand what would be regarded as systemic, because widespread and just the litmus test, because if you look at some of the news articles, the reports, it also includes incidents that happened elsewhere, and the understanding by those who believe they collectively understand what has happened. What would be the litmus test to understanding what is systemic? And also, what has been categorized as attack against civilian population pursuant to an identifiable policy. Does that exist here in South Africa?
That's an interesting one. Let me take it from the top before I answer that specific question. You see, we have a tendency in human rights and international law. Let me say within the politics of human rights and international law, we have a tendency to come up with new terms which are not legal, terms which allow politicians to drive a particular narrative. If I take you back a few years ago when the Bush administration in the US coined a term that was called the war against terrorism, it became such a strong pillar in international geopolitics that everyone talked about the war against terrorism. Why did they do that? They did that so they could justify any action they take in the supposed war against terrorism. When one peels back the layers, you realize that under the law of war, international humanitarian law, there doesn't exist a term called war against terrorism. It is not a term of law. Therefore, you cannot rally legal responses against a sociological term that is not a legal crime or a legal term. Now, take this back to what we're talking about today. People have coined a term, a sociological term that they call xenophobic attacks. They are accusing South Africa of either sponsoring or paying a blind eye to xenophobic attacks. But is this a crime? Is this a term of law? It is not. It's a sociological term. When you take that situation, the xenophobic attack situation, to the crimes against humanity, it will not fit because the Rome Statute does not know of this concept called xenophobic attack. There's no crime under the Rome Statute called xenophobic attack. That's why, at best, they can put or can they can place the allegations under under crimes against humanity, and even then it would be a long stretch. Let me come back to the question you raised about what would make this a systematic. How do you prove systematicness of anything? Now, a policy of the state that perpetuates or encourages such attacks would be a clear example of the systematic nature of these attacks. Let me take, for example, the crime of apartheid, which was classified as a crime. It was easy to classify it as a crime because there was a government in power which had policies and frameworks and laws, had all the institutions of a state to carry out the apartheid machinery. When it comes to the xenophobic attacks, it's difficult to actually blame the South African government because it is not the government that's saying, go, let there be attacks on anyone. If there have been attacks, they have not been sanctioned by the government. In fact, the government is on record just denouncing these attacks and also decrying the immigration crisis, which underlies the attacks that have now formed part of the social discourse. So that's what the litmus test for systematicness would be. Policy either of the government or of the organization which is perpetuating those attacks. Now, when you look at the South African context, yes, we've had March and March, which has been saying a lot of things around illegal immigration, but nowhere have we seen a policy or utterances of this organization or other organization or even the government encouraging or telling people to go and attack others. Instead, what has been consistent throughout has been the fact that there are individuals who are not documented and they're in the country illegally, and therefore they are violating the laws of South Africa and they must go. That has been the rallying cry from the beginning. And then the organizations then began to organize marches because people have a right to go and protest, to go and march. You cannot stop them. It's their right to say, we are marching against this phenomenon. If then there are sporadic, breakouts from those marches where certain elements begin to terrorize individuals that they believe are in the country illegally, that becomes a criminal matter. It's an act of criminality. It is not necessarily a crime against humanity because the threshold for a crime against humanity is very high. And when countries begin to play around with crimes against humanity like that, it's like crying wolf. When it actually happens, when crimes against humanity happens, the concept would have been watered down. People would have, lost confidence in the international legal system and its criminal legal framework because terms are being thrown around, loosely without evidence, without even thinking about the consequences of these particular utterances.
That's exactly my point, Prof, because as you mentioned, the characterization of what is happening and what may be seen as repeated or reoccurrences of this. At what point, and that is to assume that the ICC would even have the jurisdiction and cause to look into South Africa, and given the fact that the complaint that is being made is that the South African state is failing to act on these incidents. So where does the principle of complementarity come in, and how does it establish whether South Africa's own national policy has failed to prevent human rights violations?
That's a very, very interesting point because you don't just run to the international legal framework. You exhaust local remedies. We have sufficient remedies in South Africa as a country. We have the equality court system, where anyone who believes that certain individuals are perpetuating a hate crime, can go for redress. It's available. No one has used it. And then secondly, we have the South African criminal law. Arrests have been made. And some people are arguing, but there have been no convictions. we, I mean, investigations are underway. We don't arrest to investigate. We investigate to arrest. The police are investigating. Some have been arrested. The process will, let's allow the justice system in South Africa to take its course. South Africa has not failed to prosecute people who are accused of committing certain crimes against others. It has not refused to do so. Remember, with the principle of complementarity, essentially, it places the International Criminal Court as a complementary court to the domestic legal framework. In other words, we can't run to The Hague each time there's a problem. You must utilize whatever is available in South Africa. And our court systems are functional. Our judiciary is transparent and impartial. There is no reason for anyone to dash to the to the International Court. In fact, on the basis of admissibility, the court would likely throw out this particular matter, because for this matter to be admissible, even if it has jurisdiction over South Africa, but the matter must still go through the admissibility test. And there, we need to identify or to demonstrate that South Africa is either unwilling or unable to prosecute individuals accused of certain crimes. And that is not the case right now. We also have the implementation of the Rome Statute Act, which is specifically aimed at ensuring that our obligations under international law, under the Rome Statute, the ICC statute, can actually find expression at the domestic level. I find that there's a high likelihood that the court will not necessarily entertain this, because the office of the prosecutor must listen to the case that has been brought, the allegations that have been brought to his office right now. And he must look at the evidence that is being given and determine if indeed there is sufficient, there is reasonable belief that a case can be made here. And if there is, then that office must approach the pretrial chamber and say, we want to open an investigation in South Africa. We want to go and look at 1, 2, 3. And the pretrial chamber must be convinced that the prosecutor really has a case, that can then be argued in court later. If not, they will throw it out. I don't see the prosecutor taking this matter forward because it would be laughable.
Prof, really appreciate your time and insights. Professor Angelo Dube, an expert in international law and human rights. It's 8 o'clock. Let's take you to the news desk for a full news update with Shalani Tulongwepe.
The sound of Africa, starting strong.